So, let's see, this was several years ago. A portion of this was put out in...
Nick, why don't you explain what the Salon is first?
Oh, I'm sorry. The Salon is a story about Picasso and Braque developing Cubism in Paris, 1907. Eric Satie makes an appearance. Guillaume Apollinaire is another character. Gertrude Stein and Alice Toklas are in it, and it's the beginning of their love affair. Leo Stein, her brother, is in there. But unfortunately, that's not what came through. I talk about taking things out of context. That's not what came through in Georgia. The other aspect you should know about this is that there's a magical absinthe that you can drink, or the artists drink, so they can go inside any painting that they want and interact within. Harry Potter was doing well at the time, so I thought, what the hell, I'll try to glom onto some fantasy books. But my primary motive was to figure out what the heck Cubism is and why Cubism is important. John Hodgman wrote up the comic saying, wow, this is the clearest explanation of Cubism I've ever seen. Now I understand Cubism. So I think there is an artistic element to the book, or artistic merit. Well, I like to think.
Oh yeah.
Yeah, we have to say that, or else you're going to jail. So Halloween 2004, this is Gordon Lee right here. He was arrested for distributing a copy of Alternative Comics #2, which featured a preview of, I think it was 16 pages of The Salon. And in November of 2004, the day after, Floyd County District Attorney Lee Patterson arrested Lee and indicted him with 2 felony counts of distributing unsolicited material depicting nudity or sexual content, and a misdemeanor counts of distributing harmful material to a minor. So he had given it away. I'm sorry.
Well, actually, let me jump in here.
Yeah.
Gordon was doing a Halloween promotion, and he was taking the leftover comics from Free Comic Book Day and giving them out as Halloween trick-or-treat items. And Free Comic Book Day is a marketing initiative that our industry has to get people interested in the category. And Alternative Comics #2 was a sampler of various comics from the publisher that contained the excerpt in question. Mr. Lee was accused of distributing this to a minor. They have yet to prove that he actually did give it to a minor. It certainly came from a store, but we've seen no evidence that it was actually handed off to a kid. And instead of doing the thing that we would hope people do, come and confront him directly, parent to individual, the police got immediately involved and immediately threw the book at him. The 2 felony counts we're referring to is an obscure and never tested Georgia law called unsolicited distribution of nudity or sexual content, which I believe carried up to 3 years per count in prison, and was so broadly written that you couldn't give your neighbor a copy of the New Yorker that has Richard Avedon's last photo spread, which contains photographs of naked protesters, if it was not asked for. And it was designed so that you couldn't send unsolicited porn through the mail without the disclaimer, but it had never been tested. So he had these 2 counts brought at him, and then the 5 misdemeanor counts of distributing harmful to minors material, which is a very broad category that is basically saying this material has merit for adults but is illegal to sell to children. And of the 5 counts, 2 were to the child that they claimed at first received the comic, and then 3 of the counts were John Doe counts, which is to say, we're pretty sure you gave this to other people, but we can't prove it yet, so we're going to move forward. So with that interjection, I'm going to make move on.
So here's the offending page. Is there anybody here under 18?
Should I ask that question first?
I like to ride on the edge.
And let me point out also that one of the cruxes of this argument, if you look at this page, is that the state's alleging that this is an erection.
Oh.
And this has to do with basic graphic novel literacy, right? I'm not going to ask you to look at Picasso's genitals except for this purpose. This is an illustration of time passing. And they're taking it out of context and saying, this is an obscene image. And this is an extreme example of the kind of challenges that you're going to see on a day-to-day level. So,
Yeah, excuse me, Stacey.
I'm running over. I'm sorry.
No, I appreciate it. You're better versed in it. April 2000. Why don't you talk it through and I'll just.
Okay.
I'll run you
April 05. The fund leaps to action. We hire the best counsel in the state of Georgia, the firm Begner & Begner PC, who have been defending obscenity cases for 20 years or so. We hire Paul Cadle, who's an expert criminal defense lawyer in Rome. And their analysis is that not only do we believe he's not guilty of the crimes he's accused of committing, but the laws that they're charging him under are not constitutional. The felony that I pointed out to you certainly doesn't stand constitutional scrutiny. It was never tested. The harmful to minors law is overbroad and basically makes claim that any material containing nudity or the discussion of nudity is harmful as to minors. Well, if you're a bookseller or you're a video store owner or you're a librarian and you've got the Last Picture Show in your collection, that's a rated PG movie and it has full male and female frontal nudity in it, and the state is possibly setting a precedent with this that if this book is harmful to minors, then a film like that is harmful to minors, or an art history book is harmful to minors. And so taking the defense was not just to defend Gordon, who we felt was being unjustly prosecuted, but because the precedent harm in this case is severe. So we carried through. In December of 2005, we had our first motions hearing, and everything was heard. The felonies were dismissed with prejudice by the judge. The judge dismissed the John Doe counts, the misdemeanors, and we were left facing two misdemeanor counts. One alleging that the material had the explicit depiction of sexual behavior, which is not present. What's present is nudity, unless you recall that panel I showed you and you read it wrong. And two, that it contained the explicit verbal description of sexual behavior, which is also not present. There is profanity, but profanity is not the explicit description. So we were down to fighting these two counts, and we're about 8-9 months into it at this trial date. We're already about 30 grand into it. May, we're going to trial, and the whole team's in Georgia. Our experts, our attorneys are up there at the hotel. I just got into town. I get this call from the lawyers saying, "You gotta call me right now." It's like, okay, either something really horrible's going on or it's going away. And the answer was both. They had 18 months to prosecute this case, and they didn't bother to interview the alleged victim. So they called us the night before and said, we made an error. We thought that it was given to this 9-year-old kid. It was actually given to his kid brother. So we're going to throw this case out, and we're going to refile it and go back to start, which they can do.
And back to square.
So back to square one. We're about 40 grand into it. We're going, all the way through the process, and well, we can move on from there. Actually, no. Are you?
Yeah, I skipped
yeah.
ahead.
Okay, so back to square one. We're leaping ahead. We're having to file the constitutional motions all over again. The judge continues to throw away our motions, but we have to do it. We have to go through the process. But we're ready. We've been ready for over a year and a half. Fall 2007, we finally get our day in court. Poor Gordon and his new wife and their kids have been living with this over their heads for 3 years at that point. And they're like, okay, we can finally get this done. In the first 5 minutes of opening statements, the prosecutor admits negative character evidence into the record, tarnishing the jury's ability to give a fair trial. So we were forced to ask for a mistrial, which was granted. The next day, in the paper, Lee Patterson, who you saw this card of earlier, we vow that we're going to bring this to court and put it on the next calendar. Okay. So where it stands now is that at $100,000 defending Gordon, and defending every retailer and librarian of media in the state of Georgia against a precedent set in this case, there still is no resolution. There still is the possibility of going to court. And this is for something that should have been resolved with a simple conversation and an apology that Gordon had offered to procure or to produce several times. And so that's why the fund is here, because nobody should go to jail for comic books. If you're gonna go to jail, do civil disobedience or something. Do something interesting that changes the world. Don't go to jail for selling comic books. That's just sad.